So obviously, a law enforcement officer is what's called a protected public safety official. So if you strike a police officer, it's going to be treated as more seriously than if you just struck some normal person off the street. It's not just law enforcement. It also applies to firefighters, EMT, any protected public safety official. If you strike that person, you're going to face the felony charge of battery on a law enforcement officer. That charge is a third-degree felony. That means the maximum sentence is 5 years in prison and a $5,000 fine. It's also a charge, it's kind of unique, that the statute specifically tells the judge they're not allowed to withhold adjudication, which means keeping you from being a convicted felon. So you must be adjudicated guilty if you're convicted as charged. It's also a charge that's not eligible for any type of pretrial diversion, and it's also a charge that's not eligible for record expungement or seal. So if you're convicted as charged, you will have a felony on your record with the potential for up to a 5-year prison sentence. One of the strategies that we'll use is there's some criteria that they have to meet. The state has to prove that the person was a law enforcement officer or protected public safety official, and it has to have been readily apparent to the defendant that this person was a public safety official. So it comes up in situations where maybe the officer was working an off-duty detail in plain clothes, or maybe in their own personal vehicle instead of a marked patrol vehicle. If we can make that argument that you didn't know that the person was acting in their duties as a public safety official, we might be able to argue for a reduced charge, maybe just down to simple misdemeanor battery where you wouldn't face a felony. The other thing that we'll do in these types of cases is we're going to schedule a deposition with the arresting officer, the person that's considered the victim of the crime. Before we have that deposition, I'm going to ask you to write a letter of apology to that officer. And at the appropriate time in the deposition, I'm going to present that letter to the officer, and I'm going to ask the officer if they would agree to either a reduced charge, a dismissal, or a pretrial diversion if they'll reduce the charge. I am always surprised at how often officers agree to that. And I think it's a situation where in the heat of the moment, they're super angry, but after some time goes by, maybe they realize that the person was intoxicated or the person was in a heated emotional argument with someone, things got out of hand. I've had officers tell me time and time again, I don't want to ruin that person's life. So yes, I will agree to the reduced charge and to give us some sentencing flexibility. But either way, you and I will discuss when we meet whether or not that might be appropriate in your case. We'll talk about what options we've got, doing everything we can to keep a felony off your record and keep you out of jail.